In the last session this morning, we will consider three cases, and starting out with 24-1139, in re Estate of, is it Ibeling? All right, thank you, Mr. Dickey. Mr. Dickey, you are here on behalf of Nancy and Ibeling and Mr. Sease for the guardian ad litem. And so whenever you're ready, we're ready for you.
Please the court. I'm Gary Dickey, appearing on behalf of Nancy Ibeling, asking this court to reverse the district court's grant of declaratory judgment, ruling that the assets that are held by the Harris 6 Panamanian Foundation are not part of her elected share under 633.238. The question presented is...
Yeah, I think we need to get the clock going. Yeah. Thanks. Thank you.
The question presented is whether Mr. Ibeling, James Ibeling's transfer of assets to the Harris 6 Foundation created a trust. If it did, then the district court must be reversed. If it did not, then the district court should be affirmed. Both parties agree that a revocable trust is part of a spousal elective share. I think the disagreement turns on what the proper understanding is of what is a trust. And I think the central flaw of the district court's interpretation is the district court's understanding that a trust is some type of independent going concern that exists, like a corporation or a bank. In reality, as the case law makes clear, a trust is just a relationship that is created when three conditions are met, those of which we identified in our reply brief with the Venn diagram. So you have a settlor who transfers legal title and property to a trustee. You have a trustee that holds that property as a fiduciary for the benefit of a beneficiary. And then you have a fiduciary relationship that is created. We submit that all three of those conditions are satisfied in this case. First, there's no dispute that James Ibeling transferred the legal title of the Arizona property to Harris 6 Foundation. There's also, second, there's no dispute that, and their own expert testified in the foundation documents established that the foundation counsel managed those assets for the benefit of the beneficiaries. Third, there is no dispute that the foundation documents identify a specific beneficiary, specifically Mr. Ibeling himself during his lifetime, and then various other family members upon his death, and that the assets were held specifically, quote, for the cost, education, training, and equipment, and aid, as well as the general maintenance of those beneficiaries. And so, all three aspects of that Venn diagram overlap, and therefore, that's the creation of a trust relationship.
Any differences between the two? Like a revocable trust versus this private interest foundation?
There are, but I guess the point, and this would be the most important point of the argument today, is the foundation is not the trust. The foundation is the trustee. So just as if I went to a bank department and set up a trust through the trust department in a bank, the bank is not the trust, the bank is the trustee. And so the trust is established with the relationship. So is the foundation an independent going concern? Sure, just as a corporation is, just as a bank is. Does it have its own tax ID? Sure, just as a corporation and bank would. Is it afforded corporate shield under Panamanian law? Sure, just as a bank and a corporation. And so, you don't look at the legal aspects of the trustee in determining whether a trust exists. You look at the legal aspects of the relationship. And even if I'm wrong about that, if the Panamanian Foundation is not somehow able to serve as trustee, the remedy is not to destroy the trust. The remedy is to appoint a new trustee.
I thought that there was testimony, though, that from the folks that came from the Republic of Panama and were, I think, considered experts by the court, that there is trust law in Panama, but this is a separate animal that this is governed by. Am I wrong about that?
Sure, and I don't disagree with that, just as there's Chapter 633, and then there's Chapter 491 under Iowa law, which governs corporations. And there's chapters that govern banks. Again, The foundation is not the trust, and it's not a trust, it's a foundation. The Harris 6 is the trustee. And once that reality is accepted, then you look beyond the semantics of what Harris 6 is, and you look at the nature of the relationship. And so, you know, when the GAL talks about the intent of Mr. Ibeling, the intent is clear. He intended, as opposed to accidentally, to transfer legal title to Harris 6. He intended that it would be held and managed by Harris 6, and he intended that it would be held and managed by Harris 6 for the benefit of beneficiaries. That's a trust relationship. And so I think the district court missed the forest through the trees by looking at the aspects of what Harris 6 is as a trustee and determining whether or not a trust exists. And I think the case, you know, there's several cases we cite. I think the Hormel case that we cite in there, which involves a charitable corporation, where the court said that, no, a charitable corporation can create a trust as long as it's the trustee. I think if you were to substitute Harris 6 Corporation for Harris 6 Foundation, and you looked at the nature of the relationship, that it's a trust relationship. So, you know, as a fallback, even if we're wrong about all of that, I think the district court was wrong as an equitable matter and not disregarding the aspects of Harris 6 for the purposes of this relationship. Specifically, the GAL pointed out as a distinguishing feature is that you can't use the assets of Harris 6 to satisfy the debts of Mr. Ibeling. Well, when he transferred the real estate from the Arizona real estate to Harris 6, he did so encumbered by a mortgage. And it's Arizona property. There's no doubt that if he didn't pay that mortgage, the property is located in Arizona, Arizona law would apply. They would certainly attach to that property and sell that property through foreclosure, notwithstanding whatever the foundation documents say or Panama law may say. And so they can't, on one hand, come before this court and say, well, you can't consider the relationship a trust because you can't satisfy Mr. Ibeling's debts, and then on the other hand, transfer the assets in a way in which they're encumbered where clearly a creditor could reach that. That's just...
Can you explain to me how, in Myers, I think basically the same argument you're making here, at least arguably, was made that it was a payable on death situation, so the bank is essentially acting as the trustee. The person that put the money into the bank account is like the grantor or the trustor, has free access to the money, just like an irrevocable trust a revocable trust might. But then upon death, it became payable to somebody else, and that was not a trust. It didn't fit. We don't read that so expansively to include a payable on death. How is this? It seems like it's arguably, anyway, the same argument that was made in Myers that was rejected. What's the difference?
Back to the Venn diagram. So the first element in the top left circle of the Venn diagram is there has to be a transfer of legal title, which is not what you have in a Totten trust, which is not what you have in Myers. So when you open up a bank account and I deposit money to the bank, I don't give the bank legal title. I've created a contractual relationship in which they will hold that money in the bank account, and then they're contractually obligated to pay it anytime I make a withdrawal. And then upon my death, they're contractually obligated to pay on death to my beneficiaries. That is a contractual relationship because I always maintain legal title. And so if I were to go to a bank and fill out a withdrawal slip and they won't give me my money, I would sue and enforce the contract. Whereas it's different here.
Same, though, that if you had a revocable trust that gave you free reign to access the bank, and so let's say a bank account was the only asset owned by the trust and the trustee wouldn't give you the money, when you demanded that the trustee give you the money, you could sue the trustee, right?
Correct.
So how is that different?
Because the bank never accepts legal title. So if we created a bank account in which I say every time I deposit cash, the bank has legal title, but then I also retain the ability to revoke the whole relationship, that would be...
That's true. Because on the bank's books, they now own the money that you deposited, but they have a corresponding liability to you that they owe. So when you're doing a balance sheet for a bank...
Right. Under a normal, conventional bank account, that's a contractual relationship, and so they carry it on their balance sheet as a a liability. I was positing a hypothetical in which we created a relationship with a bank in which I said every time I make a deposit, I no longer have legal title. I only have equitable title. The bank takes legal title to the cash, and then I have an ultimate ability to revoke that relationship. That would be a revocable trust, because that's what we have here. But that's not the situation with a Totten trust, and that's not the situation with the Myers case. So the distinction is if it's a contractual obligation versus one in which legal title passes. So for those reasons and the reasons that we've identified in our brief, we would ask this court to reverse the district court's ruling. Thank you.
Whenever you're ready.
May it please the court. As mentioned, my name is Matthew Sease, and I'm here for one of the foundation's beneficiaries. At the time he was a minor, he is now an adult, Dion Harrison. We ask that the court affirm the district court ruling, and I don't think, as Judge Allers pointed out, I don't think you have to look any further than the Myers case. Myers was clear and explicit in looking through the legislative code regarding the update for the spousal shares, that only the four categories may be included within a spousal share. And a Panamanian Interest Foundation is not included within those four categories.
Argument that the PIF is just the trustee of what amounts to a trust.
That completely disregards Panamanian law, as testified to both by both of the Panamanian attorneys that testified in this case, and looking at the Panamanian code that was translated as part of this case. Specifically, Article 11 makes it clear that this entity that's created, the Panamanian Private Interest Foundation, is a separate and distinct legal entity from the individual. And that's really where we come up with this distinction.
Dickey's saying is that's the same thing as a bank is a legal entity independent of a trustor or a grantor of a trust, but that doesn't change the fact that as a separate entity, there's still a trustee of the trust.
Where's
the distinction that you're making?
The argument is somewhat circular in that because it is a legal entity that's different than a trust is not a legal entity. And in their reply brief specifically talks about that, and it cites 2 U.S. Supreme Court cases. So when you place that money into a trust, it doesn't create that separate legal entity. And that's exactly what happens with the Panamanian Private Interest Foundation. You transfer that, and it creates this new private legal foundation or legal entity that wasn't in existence at the time. And so it's talked about both by the Juan Pablo, the expert that we had, and it's outlined in his pamphlet that was attached.
Thing is, regardless of whether the trustee is an individual or a separate legal entity, the fact remains that the trust itself is not a separate legal entity, whereas under Panamanian law, a PIF is, in fact, not the person that's running the PIF, but the PIF itself is a separate legal entity.
And that's why you heard them testify that there is a separate tax ID that's issued to them. All the assets are not the assets of the individual settler or the founder, as it's called in the Panamanian Foundation. They are this separate, distinct legal entity that can sue and be sued. Again, that's different than a revocable trust in Iowa.
If you're suing the trust, you're suing the trustee, right? There's no trust to sue. You have to sue either the individual or the entity that's acting as trustee.
Trustee, and the trustee is not going to have any personal liability. They're the entity that's there that will hold the trust assets. Where I think because this private interest foundation is a separate legal entity, that's what's going to have the liability. And I think it can't be lost upon the court that Panama has their own versions of trust that as testified to by Juan Pablo, they seem exactly like Iowa or even the American versions of trust. So they recognize the same legal entities that we have here. I guess I shouldn't say legal entity, but the same estate mechanisms. They recognize wills, they recognize trusts, and then and corporations. And they somehow combined all three of these into creating these private interest foundations.
To decide whether or not this fits into the peg of the statute. The statute, 633-238 sub 1, says 1/3 of property held in trust. So is this held in trust?
I don't believe that it is. I mean, there's certainly beneficiaries, right? And there's the founder, but I don't believe that it is being held in trust in the same way that this code is making it sound.
To look at what Panama law says about what it is, or can we look at this statute and say, hey, decedent was a grantor and retained at the time of death the power to alter, amend, or revoke the trust? Because wasn't that true here?
I think that there is mixed reading in the Panamanian Foundation about whether or not once it's in there, it's revocable or irrevocable. But I'm not entirely sure. I think that the founder has the ability to revoke the trust, or at least alter the trust or foundation in some way.
James.
Yes. And he was listed as a beneficiary during his life, and then after his life, then he had the 4 named beneficiaries.
Full control to alter, do whatever with that foundation?
It's full control, but he did have some control to do that. But where I think that, in using the textual language that you're referring to, Your Honor, it says in here, 1/3 in the value of property held in trust not necessary for the payment and debts over which the decedent was a settler and retained. In a Panamanian interest foundation, unlike a revocable trust, the debts of the founder can never be used to assess or claim any of the debts of the decedent when the individual dies.
Get to that equitable argument.
Yes, but I think we're in this world too where they talk about the foundation was maybe improper because of the mortgages that were out there. Well, you can't have your cake and eat it too, because if we're going to recognize the Panamanian law and the Panamanian Foundation, Article 14 of the Panamanian law specifically says that the laws of the domicile of the founder have no bearing and effect on this. And what's clear with the Panamanian Foundation is there isn't anything that can attach to this. If you're not the founder and you're not one of the named beneficiaries, you have no access to this Panamanian Foundation. So if we're going to honor the code of the Panamanian law, then we should honor that all the way through, and specifically Article 14 that says it doesn't matter where it is, and then you look at the other articles where it specifically says the only individuals that can take from this are the named beneficiaries, and that's it. So Mrs. Ibeling has no ability to claim in this at all.
Saying that the bank, assuming it was a bank that secured the debt owed by James, it's the mortgagee, the bank's the mortgagee, right, on this property. He then transfers the property into the PIF, and let's say he defaults on the note, so the bank tries to foreclose on the mortgage. They can't do that anymore because he's somehow basically stripped the mortgage off it.
I mean, that's a little far down for what's at issue in this case, and it presents. I think that there's possibility. He would certainly, I think, probably be in violations of the terms of his mortgage when he did that and transfer that, and he's going to have certain liability for that, and maybe there could be an ability to do some sort of quit title action. Interestingly enough, I think if you read through all of the founding articles of the Panamanian Private Interest Foundation laws, the banks would have to maybe go into Panama to try to undo those transfers. There is revenue or mechanisms for that to happen, but I don't know the answer to that.
Them, not a fight between.
And it's not part of the record here, but I believe that all of those mortgages have been satisfied and the properties have been liquidated, so it's not an issue that will arise in this case. But yeah, it presents an interesting legal issue, and there's not any case law anywhere, I think, in the United States that really talks in depth about the Panamanian Foundation. So this court's going to have the luxury of tackling that task here. But I just think if you look through the testimony of Juan Pablo, his pamphlet that he testified, and I think the district court judge, Judge Raines, got it absolutely right. these private interest foundations absolutely pull law from trust law, from will law, and from corporation law. I think that if you look at this, it bears more of a resemblance to a corporation than it does necessarily a trust, because it has that private entity. And it's like if James Ibeling had transferred all of these assets into an S Corp or an LLC that he had here, but it's got that little difference of what happens when he dies with that property, and that's what brings it into this mold of a trust or an estate. And so for those reasons, we'd ask that this court affirm the district court's rulings. Thank you.
Rebuttal?
May it please the court. Judge Greer, I think your textual argument really gets to the heart of the dispute. And if you look at 633.238, as you pointed out, the test is how is the property held? Because that's really what the nature of a trust is how it's held. It does not say 1/3 in value of property of a trust that's created by somebody. It's how is the property held? And so that inquiry focuses on, is the legal title separated from the settlor, which here it is? Is it maintained by a trustee? Here it is, the foundation counsel. And is it for the benefit of others? And it meets all of those. So it is property that's held in trust. Now, then you continue on in the text, and does he have the ability to alter, amend, or revoke? And he does. As the founder, he can change the bylaws at any time. So he could dispense with the council, which is managing the day-to-day assets, and he could take control of the assets himself, or he could just flat out revoke the foundation. So in terms of the distinction between trust versus trustee, it's important to note that this trust was actually founded in 2013 at the same time that James had formed a Panamanian corporation for the purposes of doing real estate development that didn't really pan out. And so it existed as an independent foundation. It's only when he when he transferred the assets that created that relationship in which the property was held in trust.
Based on Article 14, that we have to review this under the lens of the laws of the Republic of Panama?
I think Article 14 and this whole issue about liability is not relevant because, again, corporations can hold property as trustees, nonprofits can hold, banks can hold property as trustees, and in each of those entities, statutorily and in their bylaws, it says, the liabilities of a bank and the liabilities of a corporation are not the responsibility of the owner. So to the extent that they're saying you can't attach to our assets for the debts of the founder, that's just a form of a corporate shield. And of course, there's equitable remedies to pierce the corporate shield. And so if we were suing Harris 6 as a foundation, then sure, they're entitled to whatever corporate shield. If we were to sue to attach to the property that is held by Harris 6 Foundation, we would sue Harris 6 Foundation as the trustee of the Ibeling Trust. And then we would make the argument that just as we would with any other trust. And so this whole idea that they have, corporate shield from liability, that is a distinction that doesn't make a difference because, again, they're the trustee, not the trust. With respect to, do we even need to look to Panamanian law? No, because the question presented is this a revocable trust? And that's a question of Iowa law. And we're not seeking to attach, at this point, the Harris 6 Foundation assets. If at some point we have to because the rest of the estate is not enough to pay the 1/3 share, then we can address that when that issue becomes ripe. I think because the property is located in Arizona, it's probably a property law question of Arizona law. But in any event, if they have corporate shield and they assert it, there's equitable remedies for going around that. Finally, again, if we're wrong, the remedy is not to declare the trust to be invalid. The remedy is to remove Harris 6 as the trustee and appoint a suitable trustee. And so even if everything they say is correct, it doesn't destroy the relationship, which is a trust relationship. And so for those reasons, we ask the court to reverse the declaratory judgment.
Counsel, for the excellent arguments today and your briefing. We will consider 24-1139, in re the Estate of Ibeling, I may not say that ever right, but submitted, and we will issue a decision as soon as we can. Thank you so much.